rise. The Court of Appeals Division 1 is now in session.
You may be seated. Thank you. We are here on our case number 1 CACV 170659, Savage versus CRIPPA. Counsel, as you both know, you're entitled to 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, we'd ask you're in charge of keeping track of it for yourself. And so the clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would, when you approach the podium, give us your name and the name of your client. We've read the briefs, we've studied the pretty sparse record in the case, and we've also discussed the case in our conference this morning. So with that, Mr. Cook, you may proceed.
Thank you, Your Honor. My name is Alan Cook. I'm here representing Sarah Savage, who filed a name change petition on behalf of her daughter, Kylie CRIPPA. And Ms. Savage is here in court today. May it please the court. This case seems to be the flip side, complementary case to the one that was handed down a decision in the Barron case a couple of months ago in July. I admit it's inexplicable to me, but the bottom line here is that on June 6th of 2017, mother filed her verified petition for name change for her then 9-year-old daughter Kylie in accordance with ARS 12-601. 601B permits a parent or guardian to file a request for name change on behalf of a child. The court didn't note any defects in her paperwork. The matter was assigned to a court commissioner pursuant to what I presume is some administrative order of the Superior Court that does that. There are no rules that I'm aware of or administrative orders or anything else that say that when a child is involved you have to have the matter go back to a family court if there's a family court case. Certainly mother didn't object to that happening, but it wasn't part of any administrative procedure. At the time she appeared for the hearing, she had not received a response from the child's father and had not received a copy of the response or objection that was filed by the lawyer who appeared for the father. She had...
Counsel.
Yes, Your Honor.
Your client put forth the reasons for the name change from her perspective.
Yes,
correct?
That's correct, Your Honor.
Would her presentation of those reasons have been any different had a timely objection been made or provided to her? And did she alert the court to, hey, I can't present what I wanted to present because this objection, which I just got, is way too late?
Well, Your Honor, she didn't know that an objection had been filed that set out that father's position that this child had never asked for a name change. And if that had been told to her, she could have had the child see a psychologist or somebody like that and relate to them, too, that this was the child's idea because she has an older sister named Jasmine who had adopted children, and she had gone to the name change proceeding. So this is how she found out about it, and that's why she asked her mother to do this. She thought it was only fair that her mother's name be part of her name. And
well, but my question to you is, did your client object to the court and say, Your Honor, I can't proceed today because I just got this and I can't I can't address it because I just got it.
Well, Your Honor, she wasn't told about the objection and the allegation that the child had, by the father in his paperwork, unverified paperwork, that the child had never said that she wanted a name change to the father.
So she wasn't handed a copy, or I'm asking,
No.
was she handed a copy when she came in?
No, Your Honor. As we relate in the briefs, she didn't even. The other lawyer said that they had emailed a copy to her or sent a copy to her address, but as of the date that the motion for new trial was filed on August 3rd, she still hadn't received a copy even via email. So she never did get a copy until she went on turbo court. That's the only way that she got a copy after the hearing.
But at the time of the initial hearing, did your client know there was an objection, whether she actually physically got it or not?
She knew that they showed up to object, and she knew what was said, but she didn't have a copy of any objection. She wasn't aware that there was a written objection that she
When
should
did
have.
she learn that there was a filing that she did not have for that hearing?
You know, Your Honor, I don't think it's reflected in the transcript itself that she got it because she didn't get one at the hearing. But she knew that father's lawyer showed up, and I think there was made mention, I think the court made mention that it had an objection, but she didn't have a copy of an
Clerk, I
objection.
think, on the record
Yes.
says something like there is an objection.
Yes, but it didn't say, court didn't say, I've got a sworn statement here from somebody that says the child never asked for this, and in which case mother could have said, whoa, okay, that's different, so she could have proceeded. And in
Your
fact,
position is that even as she went through the hearing, she understood there was an objection, but she didn't know there was some written document.
no, she didn't get that. So she didn't get that until afterwards. She was, yes, Your Honor.
And were the arguments made in opposition to the petition orally in court, were those different than the objections that were in the written objection?
The arguments were principally, I think, fair to call mudslinging, Your Honor, accusing my client of wanting to somehow minimize the father in the child's life. And but even the allegations made aren't supported by the divorce court record.
Well, but
yeah.
my question right now, though, is, are the reasons in the objection different than the reasons that were presented orally in court?
They're not identical. And I think they're essentially the same, except I think that the statement, in fact, I've given the court a copy of the transcript. I think the statement was made in court, but there was no testimony given in court with respect to this allegation that father didn't know that the child said this. And I've got my transcript. It's very brief, and I'm looking to see where it says this. So it's starting at page 35 of what's attached to the petition for review. It's page 5 of the transcript. And the argument is that says that the father has spent more than $100,000 battling. They were married, child conceived, 9 years old, equal parenting time. And he says, my client firmly believes never asked to have her name changed. Okay, so that is said there, but it's a statement by counsel. It's not testimony by anyone, Your Honor. And so they make argument it wouldn't make sense. But at the same time, there's nothing verified filed anywhere. There's no affidavit from anybody. There's no sworn testimony from Mr. CRIPPA that the child never said this. And so it just seems to me that there's an inherent lack of due process when the court is given paperwork that makes these allegations and it's not given to the other side.
Was
And
a copy given to the judge?
the judge had it, and he didn't give it to her either, Your Honor.
We know that?
Yes, Your Honor. It would be in the file if that were true. It'd be a reference to it, and the trial court didn't give her a copy either.
I think what we're asking now is whether we know that the judge had it on the bench. It looks to me as if there were two copies of it filed. One that was stamped in, probably the clerk's office, and one that was handwritten, which may have been, I infer, handed to the court.
Yes, I think
I don't know that.
My reading of the transcript previously, Your Honor, was that the court mentioned that it had received an objection.
Okay.
But let me,
But we can find that in the
Yes.
transcript. Let me ask
but
you.
may not have.
Yeah, I take your point that the only evidence, admissible evidence before the court is that which was offered by Mom.
That's correct. Mother's the only person
Okay.
that testified, even though Father was also sworn.
But we know
Yes.
that the court need not accept uncontradicted evidence by a single witness. It has the discretion, if it doesn't believe the witness, to find otherwise. But the court didn't say. I don't think we have anything to tell us that the court denied the application because it didn't believe Mom. I think that what the court said is it thought Mom was using this as leverage and it would cause disharmony. Talk to us about whether the fact that Dad objected to the application, it would make him mad if Mom's name were added to his daughter's name. How does that reflect on the best interest of the child?
Well, Your Honor, the Lax case kind of points to this, and I mentioned that in my brief, that the court in that case stated that it certainly seemed discriminatory to say that the father's last name is going to be the child's last name and the mother doesn't have a right to have her name be part of the child's last name. And in this case, Mother didn't ask to replace the child's last name and didn't ask to make her last name the child's last name. She asked that she have a second middle name with her name, Savage. And so it's hard for me to perceive that there can be any valid reason for objecting to this other than just sheer nastiness. And other than that, there's no reason for that at all. This is something, for example, Father had a lawyer. He had these papers early on. Father's lawyer could have written a letter to Mother and say, why do you say that Kylie says this? And they could have addressed this, but they didn't. Instead, they show up the day of hearing and don't give her a copy of their objection. And then the judge, obviously, is relying on what is said to him either by Father's counsel in argument or in whatever Father filed when he makes this assumption that somehow this is some kind of a hotly contested issue that the divorce court should address, when in fact there's no procedure set up here in Superior Court for that to happen. It's something that Father could have asked for. He could have made these allegations in something and asked the court to refer it to the family court judge. Could have done that. He didn't do that. Instead, just showed up and objected, presented no testimony whatsoever. And I understand what you're saying. There is a case out there, floating out there somewhere, that says that the court doesn't have to believe even the uncontroverted testimony of an interested party. But on the other hand, I think it also implicit in that is that I think the argument that sometimes you have an issue that one party has no ability to investigate or disprove, and the other party just makes a bald assertion that there's no way to contest it. You can't cross-examine it. And if you look at it that way, that makes sense. But here, there was a way to deal with this, with timely notice.
I'm not asking.
Yes.
I'm not asking about that. What I'm asking is, it seems as if what the court relied on is Dad's counsel's argument that Dad didn't want this name change for whatever reason. Is that sufficient? Is that the best interest of the child simply because Dad objects?
No, Your Honor, it's not. I would submit to you it is absolutely not. The fact that Dad objects is not a reason. Just for openers, the Superior Court saw fit to give my client the sole decision-making authority with respect to the major life decisions of the minor child. And although there is a case that says that the father has an interest in whether or not the child's name is changed, there's a difference when a parent wants to change, for example, their child's name to that of a stepfather and remove the father who is actually active in a child's life, as opposed to wanting to give the stepfather who's adopting the child's last name, which is a different reason. Here, there was no reason advanced whatsoever for denying Mother's request, and there was no evidence to the contrary with respect to Mother's request, and there could have been. There could have been. This is not a case where there couldn't have been something done in the 35 or so days between the time the petition was filed and served and the hearing was held. There's no reason this couldn't have been done. And so,
Counsel,
yes, Your Honor.
You talk about the difference, you allude to the difference between mother wanting to add her last name as opposed to wanting to add a stepfather's last name or some other variation. And in this case, to be sure, it was mother's last name, mother's family name, surname,
Yes.
not her husband's, partner's, or otherwise.
That's correct, Your Honor. Mother's
Okay,
last
and what
name is
is the
Savage.
difference between mother's last name or some other permutation?
Well, Your Honor, there's a sense of family that goes with carrying a family name. And certainly in the Hispanic community they know this because the mother's name is the primary name that the children get typically in Hispanic families. And there's a reason for that. You always know who the mother is. You may not always know who the father is, but you always know who the mother is. But there's a sense of community and family that goes along with that. And that's what gave rise to Kylie asking her mother here. And because it was her idea, because she didn't have a mother's last name anywhere in her name. And mother didn't ask to delete father's last name. Now, I wouldn't be here arguing this case if this was mother saying, substitute my name for father's. I wouldn't be here. Mother didn't do that. And so you're talking about what, on the face of it, is an innocuous change to just include a name as opposed to deleting some names, and particularly where mother didn't ask to delete the father's last name.
So are you talking about equality here?
Well, I think there is equality in terms, if you're going to use the argument that the court doesn't have to believe even the uncontroverted testimony of an interested party, then I think one of the things that you need to look at is what is it that you're talking about? Okay, we're not talking about one spouse saying he took $500,000 out of a hole in the ground and sent it to Korea, and father has no way to disprove that. You're saying you have a child here who'd also like to have her mother's name, which sounds eminently reasonable on the face of it. And you're talking about a child who knows about name change procedures. They haven't disputed that, by the way. They haven't disputed that Kylie's cousins had their name changed or that she knew about that procedure. There's no evidence, in fact, in the record at all from the other side. All you have is mudslinging and hearsay, and it's arguments of counsel that aren't admissible as evidence, Your Honor. And yes, sir.
I got two questions. First, as I read the petition and the argument, your client sought the name change because it would be beneficial to the child. I didn't.
Yes. Because the child asked for it, Your Honor. Yes.
I didn't understand that one of the reasons is because it's only fair to the mother. Was that argument advanced below?
Well, at the time of the hearing, Your Honor, keep in mind, mother wasn't given copies of father's. She didn't know what position he was taking. And so, but she certainly raised it in her motion for new trial that certainly mother has every right to have her child carry her name as father's, and there's nothing unreasonable in that.
But
So,
that wasn't one of the initial reasons.
well, I think it is. If you read the petition, that's basically inherent in the petition, Your Honor, that the reason she's doing this is that her daughter had asked her and she believed it was appropriate, and therefore she was making this request to the court because it was in the child's best interest.
Well, I won't belabor
Yes.
that, but that's for the benefit of the child, not because
Yes.
of any right the
Mother never said she wanted to do this because it was in her best interest. She never said that.
And my second question is, I understand your ultimate goal and your client's ultimate goal is to have the child's name changed. But as far as what we're here to decide today, are you just asking us to remand it to the trial court to make further findings on the record to either support that it's not in the child's best interest or that it is?
Well, Your Honor, that would be my client's secondary request. I think the record supports the fact that the child should have mother's last name as part of her name, so it would be Savage, space, not hyphen, CRIPPA, as opposed to just CRIPPA at the end, so she would have her name added, rather than have to go back to another hearing, which could be done. I think certainly if you're inclined to deny ordering the Superior Court to change it, then she would want to have a hearing on, because yes.
Do we have the authority?
I think you do, Your Honor, because there's no evidence to suggest that mother's request is unreasonable or that it's untrue. And they had ample opportunity to present evidence themselves and chose not to do so. And they also had ample opportunity to do an investigation and chose not to do so. I would like to reserve the last minute of my time, if I may. Thank you.
Good morning, Your Honors. My name is Carla Callahan, and I represent Gary CRIPPA, father, in this case. I don't have a lot to add to anything of the details because it was a short hearing. Father, according to the rules, did not even need to file an objection. Mother knew that he was coming to that hearing. She even stated so in court in her briefs that she didn't bring the child because she knew father was going to be there. She also obtained...
Did mother know that he would be there to oppose the petition as opposed to being present to witness the hearing?
Yes, he did. The counsel at that time had emailed mother and told her that father was objecting. He did not want the child's name changed, and the child had told him that she did not want a name change, that she wanted to leave it the same.
When did counsel for father provide a copy of the document to mother?
The objection.
Of the objection. Mm-hmm.
That I don't know exactly when it was. I was not the attorney at that time. I know that according to the record, it was not given to her at that time. But even in the rules, it does not state that father had to file an objection. The rules just state, and the order to appear, the notice for application just states that there is a court hearing going to be on July 19th, and if you want to show up, show up.
Was a copy given to the judge on the day of the hearing?
As far as I know, yes, Your Honors. I don't know for positive because I was not there.
So even though father's not required to file anything, do you believe that when he does, he can provide a copy for the judge to consider in front of mother and not provide her a copy?
That would be up to the judge. I would assume that the judge would have made a copy and asked her, did you receive this? That is what would happen.
Well, that didn't happen here, did it?
As far as the record, no, it did not.
Okay,
And
so back to the question, father's not obligated to file an objection, but when he does, do you believe it's proper to then offer a copy to the judge and not the other party, the proper party?
a copy should have been provided. However, I don't believe that the judge took it on the objection, and that's how the court ruled, is just from that objection. I don't believe that's how it happened.
So, well, but when counsel files the document and brings a copy, then don't you think that there's a duty then to bring at least 2 copies? Here you are, opposing party, here you are, judge, as opposed to here you go, judge, and nothing else.
Correct. And I understand from the record that counsel at that time said she emailed mother a copy. And then I understand also from the briefs that the mother did not receive a copy by email until at a later date. So that I was not in at that time on the case, so I do not know who received it, when, and where, but it was stated that counsel did email mother the objection.
Well, let's get, oh, go ahead.
What I'm concerned about, and I think that you can tell the court is concerned, the record seems thin in this case. The court's minute entry says the court finds that the application is being used as leverage in a family court matter, and the change of name of minor would only cause more disharmony. What evidence was presented? What did the judge know about the prior family court matters that would support that conclusion?
Well, I guess it would be counsel's avowal to the court that father spent.
Argument.
Yes.
Argument to the court.
Correct. Yes, I'm sorry, Your Honor. The argument to the court that it was thousands of dollars that were spent in
What does
years.
that have to do with a name change? The fact that dad has spent $100,000 litigating other matters, because I don't think anybody's saying here that father spent $100,000 litigating the name change issue, and here she is again asking for the same thing. That's not what we're talking about, right?
No.
Okay,
And-
so he spent money on other matters. What does that have to do with putting mom's name on adding mom's last name?
Well, I think because the courts understand that when you have a family court matter, that parents will bring it to the court's attention to try to change the child's name. These parties were married. Mother had the last name CRIPPA. She changed it somewhere after 2016. So mother and child had the exact same last name for a time. Mother chose to change her own name.
She divorced him.
Correct.
So in other words, if she wants to continue to have the same name as her child, she has to keep the name of the man she divorced.
It was mother's choice to change her name. But the child was already 9 years old, going to be 11 in just a couple of months. The child had the last name of CRIPPA the whole time, 9 years. And then mom wants to add her name, and that was only after the divorce. So I think that she was, and the court could clearly see that mother was trying to frustrate the family court matter as it.
And I mean, I take your point on that, but what is in the record that would lead the court to draw that conclusion?
I'm not sure what was in the record, as I don't see that would draw the court to conclude that, other than if the court looked at the family court record and seen that it was heavily litigated.
Do we know that the court did that?
No, it does not show from the record that the court did that.
We have in I think appellant filed an appendix that included a copy of a order that this commissioner had entered at a couple years before in a protective order matter. Mm-hmm. So from that we infer that particular commissioner had seen these parties at least once before.
Correct.
Do we know that commissioner had touched these two parties on any other occasion, so to speak?
We do not know that, Your Honor, and I don't see anything in the record that would show that this particular commissioner had any prior experience with these parties.
Did you say earlier that the court, in terms of mother's due process argument and not receiving the objection in a timely fashion, the written objection, was it your position that did not result in any prejudice because the trial court did not consider the written objection? Did you say that?
Yes, I do believe that the trial court did not put it on the record that the commissioner actually reviewed that document, that objection, and stated that this is the reason why that ruling against mother on that case.
Okay, so then if we're reviewing and of course understanding that the court is not required to make findings absent a request by the petitioner, which was not made in this case, but did make a statement about the reasons for denying mother's request, right? Correct?
Correct.
Okay, so then we look at what those reasons were, and your position is it certainly wasn't based on your client's objection. So looking at the reasons, the court says at the hearing, this is one of those unique situations to where it's intermeshed into family court, and then now there's a civil application. This court will not get involved in a family court matter and will not fuel either side. So a couple of questions from that. First of all, will not get involved in a family court matter. Do you believe this was, the request for a name change was a family court matter?
Technically, no, it would not be the family court matter, but mother could have brought it up in the family court, and she didn't.
But she didn't have to.
No, she did not.
Okay.
And just like father didn't have to file the objection, so he could have shown up that day without a paper copy of anything and just stated the objection on the record.
Okay. But he didn't do that. He didn't state anything on the record.
No, his attorney did.
And that's not evidence.
Correct.
And so then, so first we agree that this was not a family court matter, and then also, and will not fuel either side. What does that mean? And how does putting mother's last name on equal footing as father's fuel some side? How does that give mother any advantage? How does that hurt the child or the best interests of that child?
Well, mother states that the child wanted the name change, but the child did not testify to that. It was just mother and her hearsay that the child wanted that. So that's why I believe that it would fuel the contention between father and mother. This was
It would upset father.
probably, yes.
Do you think that's sufficient? Do you think under a scenario like this that the father, considering that the issue the cases teach is the best interest of the child, do you think it's sufficient that the father can veto a name change application like this?
Not veto, Your Honor. I do believe that the father does have a say-so that the name not be changed after the child had this name for 9 years, born with this name, and it was mother and father divorced. The child didn't divorce.
Well, it's not as if the change would have deprived the child of the same last name as she's already had.
Correct. But then we're still changing the child's name, that she wasn't born with that name. Mother chose, when she did get married, to take on the name of CRIPPA, and she chose, after the divorce, to take her maiden name back. So
just so I have it in my mind, what's the best argument to be made on the evidence before the court that the name change was not in the best interest of the child?
that the child was born with this name and had the name for 9 years. Why should we frustrate the child or any other matter? Like Mom put in her petition, I think it was, that because she had the insurance on the child, that it would just make it easier that Mom have the last name, her last name, in the child's name. I don't think that just because Mom has the insurance that the child's name should be changed, but that was one of Mother's reasons.
Do you believe there's a difference between a name change where you add Mother's last name or some other scenario, whether it be adding a step-parent or changing the first name, any other scenario? Is there a difference when another parent requests to add their name?
Well, I do believe that the name shouldn't be changed because the child was born with that name until the child can say for themselves at 18.
Well, that doesn't answer my question. My question is there any qualitative difference between the requests that I'm positing? So, for example, is there a difference between our scenario where Mother wants to simply add her name, or, hypothetically speaking, a child who's having gender issues and is biologically a girl and wants to have a boy's name? And Mother says the child should be called by a boy's name, and the child is 9. That's one scenario. Or I remarried, and I have another child, and we have this new family, and we want to delete biological father's name so that it's easier for us to move on with a new last name, and I want her to take on my husband's last name. Is that different? Are those different from, I don't want to disturb father's last name, but I want to add mine?
It is different. I do understand your point that, no, we're not changing the entire name, we're adding to.
And what we're adding, right?
Correct. We are adding Mother's maiden name on there.
Not some random name.
Correct.
So why not?
Well, because what if Mother gets remarried? is she going to want to add her new last name to the child also?
That's exactly the point of my question. Is there a difference between adding mother's maiden name?
Well, if we added mother's maiden name now, mother gets remarried, is she going to want to change the name again?
It's speculative here.
It is speculative, Your Honor.
That's why the question, is that different from what we have here? Some other name versus a name that's predetermined at the time mother was born, her family name was what it is, and she was given that name, and that's constant. I mean, whether she decides she wants to carry her family's name or not, that name will be what it is. And that relationship the child has with mother and grandparents and great-grandparents, I mean, that she comes from that lineage, right?
Correct. And what I see different here is if mother wanted the child to have her maiden name, why wasn't the child born with that name and put on the birth certificate at the time of birth?
Well, that's like saying if mother knew she was going to divorce dad, why did she take his name? I mean, isn't that the same? If you knew this was going to happen, why didn't you make the decision years ago? I mean, most people who knew they were going to divorce someone probably wouldn't take the last name or get married in the first place.
Correct, but that's what mother's arguing now, is she wants not just to have her last name that mother has, but also the family. She feels that the child would be more bonded to her family. So that's what I'm saying is the child, if mother felt that way, she should have been born with that name or put on the birth certificate at that time, not 9 years later just because of the divorce.
Counsel, as I'm looking at this case on appeal, the trial court denied the petition, finding that changing the name would only cause more disharmony and was being used as leverage in the family court matter. As I take my job, the standard of review is did the trial court abuse its discretion in denying the name change, and this was the reason that was given. In deciding whether there was an abuse of discretion, though, I need to determine if there was evidence in the record that supported that finding. And I think we all agree the record is there, and I'm searching for evidence that would support that, and I'm having a hard time finding that. Can you help? I mean, where is it in the record that supports the finding of disharmony that the mother is using this as leverage?
I don't see it in the record. However, this commissioner did have... Oh, go ahead.
Well, but if it's on the record, then doesn't that end the matter then? Because what we have is what's in the record.
Correct. And then we don't know what the commissioner had researched on this. If the commissioner looked at the docket and seen that this was a heavily litigated case in family court, then he could then see that this is going to frustrate the party. A mother might be doing it to frustrate. That court had the
court didn't say, I've looked at ISIS, I've looked at the court record, and that's why I'm concluding that the court didn't say that.
Correct. No, the court did not say what it also took into account. But it also did not say that it took father's objection and used that part of anything to make its determination.
So if we were to find that the trial court abused its discretion in denying the name change, what happens then? Does it go back to the trial court to reconsider this, or does the trial court have to allow the name change?
Well, I thought it had to go back down to the trial court too for reconsideration or a new hearing. And if mother believes that she needed ample more time to research father's objections, then so be it. Then she'll have her time. But I do think that it needs to be, if this court, that you wouldn't be able to just change the name, that it would have to be remanded back.
Well, as we've gone over before, the court did not have to give reasons, but it did. And if we find that those reasons are unsupported, then couldn't we just say that mom was entitled to relief if the reasons were not tenable? And relief is simple to determine.
I hear what you're saying, but I do believe that it needed to be remanded back so that way the objections could be heard and a more clear record could be made.
And lastly, could you tell me what is the leverage that mother gains by adding her last name?
Well, I deal a lot in family law, and so the leverage, even with sole versus joint and names, they play a major role in the family court system with divorced parties with children.
But
so
how? Just quickly tell me how. What happens? What does she get?
I can't think of an example right
And
this
the
second.
judge didn't say what that might be.
No.
Okay.
She gets a win.
True.
But I don't hear you on appeal saying that the leverage thing or avoiding disharmony is properly factored into best interests. When I ask you why wasn't this name application in the child's best interest, what I understood you to say, it's just not in her best interest to change her name at this point in time. She was born with this name. She'd had it for 9 years. It's not in her best interest now to change it because it would be a change.
Correct.
Okay.
So are you conceding that disharmony is not, it cannot factor into the child's best interest?
Oh, it can factor into the child's best interest, that disharmony would probably take place in this case because it's been there from day one.
But to be clear, when we say disharmony, aren't we really saying upsetting dad? Because if she gets the name added, there will be no disharmony from her side. I mean, she'll be pleased. So it really isn't, it's going to throw contention. It's just going to upset father. And so it may not be in the best interest of the child. Things may not fare out as well for the child. Is that what we're saying?
Not just upset father, but mother's the only one that's stating that the child wants this name change. Father's hearsay saying...
Father's not saying anything.
Well, he's saying that she doesn't want the name change.
Well, father did not testify.
No, he did not.
And because I find that curious, because mother testified, and then as I read the record, the court turned to your client's counsel there, and said, what's the objection? Why wouldn't father have testified then?
From the record and from what I've read, it just seemed like the attorney took over and stated what father's positions were. The court did allow mother a chance to cross-examine father, and she chose not to. She could have asked him directly, why? Why not?
Why would she call him if he's going to take a position contrary to her position? Isn't it to her advantage to not call him? I mean, why would she call him to put into evidence something that is diametrically opposed to what she's presenting?
Well, that's a good reason why she didn't. But then she's also arguing here today that she didn't get the chance to or father didn't testify, and so, but he could have. She could have asked him questions, and she didn't.
So that was the court's opportunity to allow her cross-examination.
Right.
Okay.
Okay. Thank you.
Done?
Yes.
Thank you.
Thank
you.
Thank you very much.
Thank you, Your Honor. I have about 5 points to make.
Well, you can take a couple minutes more.
Thank
To
you, Your
make
Honor.
5 points. I'm counting.
First, Your Honor, mother never got a copy of the objection, ever. The fact that her lawyer said she emailed her one doesn't mean it's true. I had filed something with the court making note that as of August 3rd, she still hadn't gotten an email of the objection, and if that had changed in the interim, I would have given the court a notice about when it arrived. The fact of the matter is, there never was one given to mother, contrary to what's said here by counsel. And I think counsel believes what she says, but she's not the lawyer that represented father. With respect to a copy, father's counsel never gave her a physical copy either, neither did the court. 3, I don't think on this record there's any way that you can read what the court said at page 7 of the transcript and not think that the reason the court denied the application is because of the objection by father and what father's counsel said, not because of the evidence presented. 4, I agree there's zero evidence of disharmony in the record other than the fact that father showed up and his lawyer objected. And the court apparently treated the lawyer's comments as evidence. 5, Kylie's little sister wasn't born until January of 2017, and that's what gave rise to Kylie's request to mother, and that's in the record. That's why she wanted to have the same last name as part of her name that her sister had. So that's mother's reason for asking to have her name Savage added. 6, father showed up and he had a lawyer. Why didn't he call Kylie? If he was going to show up and say that Kylie didn't want this, he could have called Kylie. Now, then you get to ask about who's got the child's best interest of heart, bringing this 9-year-old into court. But nonetheless, to say that mother should have called Kylie, father could have called Kylie to say she didn't want this. So father knew mother's position going in. And I would say, father doesn't have to call his daughter Savage at his house. I mean, how many fathers call their child by their last name anyway when they're at home? Kylie, do this. Kylie, do that. Honey, do this. Honey, do that. They don't. It's not going to say, Kylie, Savage, do that. I mean, nobody's saying that father has to call her Savage if he doesn't want to. Last but not least, I submit to you that on the evidence and on the record in this case, that basically what happened, the trial court gave father a veto by filing an objection. That's what happened. And I would submit to you that there's an element of sexual discrimination in that. It's just plainly inappropriate. There's nothing on its face unreasonable about mother's request, and I would submit to you, here we have father complaining about mother running up all these legal fees and costs and all that, and that's part of what they say. And mind you, in the answering brief, they cite almost no facts. They don't cite any facts in the records in support of their position. But the fact is, they made this claim, father had spent $100,000. Well, why do they want to have to go back and have another hearing to have something so innocuous? How can the court think that this is anything but just spite on father's part to have a hearing about this?
Are there, the child's nearly 11? Is that what I heard? No.
Going to be 11 in December, Your Honor.
What issues would be implicated by having her testify at this point about the name change issue?
Your Honor, just the fact that you're asking the child to choose between what their parents say. And I would tell you, I mean, under ordinary circumstances, I think, with intelligent parents, you wouldn't have a parent castigating the child later for disagreeing with what one of the parents had said. Okay. But you don't have it in the record here about who it is that says things. Well, you do have it in part. You have the 1-minute entry I provided, Judge Polk's finding. There's a reason that he gave mother the sole decision-making authority here. You can divine what that is, I think. But, you know, there is one party here who hasn't alienated the child. And,
so you're saying that brings to bear a whole host of other issues?
Well, but that's because you have parents that are irresponsible in looking after their child's mental health. And this isn't something that should have any effect on that at all. This is something that father doesn't even have to deal with. I mean, he can, if he wants to sign her up for something, he can sign her up as Kylie CRIPPA if he wants to. He doesn't have to say Kylie and then her middle name and then Savage and then CRIPPA. He doesn't have to do that because CRIPPA is still going to be your last name. And even though my name is S. Allen Cook, my mother called me Allen all my life, and when I got signed up, it was Allen Cook. It wasn't signed up as S. Allen Cook. And how many people do sign up people using all three of their names? Because most people have three, and in many families they have 4, 5, or 6 names, depending. So, but as a matter of fact, I think there's zero inconvenience to father here. And you know, it's partly the reason we've asked for the fees that we have in form of sanctions for having to even do this. But thank you very much for your time.
Thank you. Thank you to both sets of counsel for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Before we let the lawyers go, is there a sign-in sheet that's been completed? Okay, very good. We stand adjourned.